All rise. Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Thomas D. Sawaya, Judge, presiding. All persons having business before the court draw near and give attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right. I was going to say good morning, but this is the afternoon, obviously, and we're having a session in the afternoon because we have a conference scheduled for next week. We have 3 cases on the docket this afternoon. Let me introduce the panel to you. Seated to my left is Judge Orfinger, and to my right, we're pleased to have Judge Howard Maltz as an associate judge, and we're happy to have him sit with us to help resolve the cases on the docket this afternoon. He is a circuit judge from St. Johns County, and again, we're pleased to have him. The cases will be heard as presented on the docket. They're all civil cases, so each side will have 20 minutes allotted. If the appellant wishes to reserve any time for rebuttal, let me know. We have a clock on the podium that will assist you in keeping time, and if there's a problem with that, let me know, and I'll try and assist you as well. If you have any electronic devices, please turn them off during the course of the oral argument so that we're not interrupted. And after the second case, we'll take a short 10 or 15 minute recess, and the attorneys are welcome back to the attorney lounge for some coffee. Hopefully we'll have some coffee prepared for you. So with that, we'll begin with the first case, GELMAN versus CAUFIELD.
May it please the court, David Oliver on behalf of the appellant Jeffrey GELMAN. I filed my notice of additional appearance by electronic filing on Thursday. Okay. I don't know logistically if it's made its way to the panel's file, but...
I have not seen it, but I'll take your word that you filed it on Thursday.
Thank you, Your
Okay.
Honor. And with me at council table is Scott Smothers, who has been appellate counsel from the outset of the case. I believe that when the court looks at what Judge Mihawk ruled as the trial judge below, I respectfully submit that we're quickly going to segue into what I would characterize as a tipsy coachman argument, because I don't think it can fairly be said that Judge Mihawk followed the precedent of this court. In the First State Savings versus Albright decision of the 5th DCA. I won't belabor the facts because they're so simple and I think everyone knows them. Mr. GELMAN on his own had 2 appraisals commissioned of his house in Orange County, Florida. One came in at $23 million, the other came in at $26 million. Those appraisals were not performed by the appellee in this case. They were performed by independent appraisal firms. But based on those appraisals, Mr. GELMAN went to his bank, JP Morgan Chase, and requested a loan of $10 million, and he got preliminarily approved based on the values that apparently were reflected in the appraisals that he commissioned. The preliminary approval was contingent. It was contingent upon the bank receiving an appraisal satisfactory to them, their loan committee, and whatever their loan ratios are to approve the $10 million loan. Chase apparently contacted an appraisal referral service based on the record allegations contained in all parties' briefs, one of whom was the appellee.
Was there anything in the record that put them on notice that the loan was for purchase of another piece of property other than refinancing of the property that was being appraised?
No, sir.
How can you claim, in the absence of that knowledge, or even if that knowledge was present, one of the requisites of Section 552 liability is justifiable reliance? If I understand the course of events, after your client went to the bank and the bank said, we think we can loan you $10 million if we get satisfactory appraisals, before the appraisals were done, he had committed to purchase this other piece of property. So, and then the appraisal is done after that. How can he claim justifiable reliance when he had entered into the contractual relationship to purchase this other piece of property even before the appraisal had been done?
Judge, he can't claim it based on that future or that transaction that would have been unknown to the appraiser, and in fact unknown and already entered into by GELMAN. Our proposition that we advance and argue to this court is the reasonable reliance in a refinance of an existing home where the borrower is obviously pulling out money as opposed to simply converting to a lower interest rate. Clearly, the borrower has some reasonable expectation that the appraisal will be conducted in a non-negligent, commercially reasonable manner. And that is the only...
Of course, that's premised on the concept of duty. And, you know, I guess that brings us back to maybe where you wanted to start. Upon what do you base the idea that the appraisal firms that the bank retained owed your client any duty? I mean, I know you've looked at the Max Mitchell case and other cases that talk about when information is known to be relied on by outsiders, but the facts here are substantially different than Max Mitchell.
Clearly, as to the gay feather transaction, Judge, there was no knowledge that could be pled nor was pled on the part of the appraisal firm. But going back to where I started, and then I'll directly answer your question, what Judge Mihawk ruled was that when a bank hires an appraiser to perform an appraisal for credit to a third-party borrower, the appraiser owes no duty to the borrower. And that's not what 552 says. It says if the professional who is publishing or delivering the information delivers it to a recipient that he knows will rely on it, or knows that the recipient will forward the information to influence the transaction at issue. The transaction at issue is not a purchase of undeveloped lots from Gayfeather. The transaction at issue for purposes of 552 is the refinance itself. And Mr. GELMAN had a reasonable reliance on the fact that the...
What about the reasoning in Cooper where the court basically explained that this concept has to be limited, otherwise you're opening appraisers up to liability for just about anything. And in Cooper, it said that it was for a loan transaction and it was limited to that. Here we have a loan for repurchase of another piece of property that the bank wasn't even aware of. So what about the reasoning in Cooper? Why wouldn't that apply in this case?
Judge, I think the plaintiff in Cooper grossly overreached and overstepped, because the damage that the plaintiff in Cooper claimed did not arise out of the loan transaction. It arose out of a purchase and sale transaction. He alleged, I never should have bought this house had you, the appraiser, properly discovered latent termite damage in the house. And the court said, under 552, that's a completely different transaction. It's a purchase and sale transaction that the appraisal firm had nothing to do with. Had the loan come in at a grossly excessive or grossly...
If the bank doesn't know the purpose, the exact purpose for the loan, and that the borrower wants to use this money to buy another piece of property somewhere else, according to the language in Cooper, without that knowledge, that opens the appraiser up to liability for just about anything that the borrower wants to do with the money, is if the borrower feels that the appraisal wasn't appropriately done. And there's no way for the appraisal to even have a reasonable expectation as to what their liability is going to be. It's not even reasonable foreseeable.
Judge, I understand that argument, but that's what I would refer to as a Paul's graph argument and approximate causation argument. We never got to that point.
Isn't that basically what the court in Cooper said? That, I mean, you have to limit this concept. You can't just keep it to, or expand it. You have to keep it to a limited number of cases so that the appraiser will have some idea of knowing, you know, what their liability may be in the event that they make a negligent or wrongful appraisal. And the court said that it has to be limited.
Clearly, that was a concern expressed by the Cooper Court, Your Honor, but
Is that reasoning wrong?
I think it is wrong, Judge, because the purpose of 552 had to be to expand the liability of professionals beyond those with whom they're in direct contractual privity. Otherwise, it's a meaningless nullity.
Well, but if you look at subsection 2A of 552, it says that the liability established in sub 1 is limited to loss suffered by the person for whose benefit and guidance he, in this case appraiser, intends to supply the information or knows that the recipient intends to supply it. So here, the appraiser provided the information for the guidance and benefit of the bank to make certain that they met whatever their lending criteria is. Why doesn't, even assuming that we could get past the concept of duty and justifiable reliance, why doesn't that section, it's limited to those by the person for whose benefit and guidance he intends to supply the information? I'm having a hard time seeing how the appraisal was for the benefit and guidance of anyone other than the bank.
Your Honor, because of the language which you read the first time you went through it, which is critical for this analysis. Or, and I'm filling in the words "a person" because the sentence isn't the best written English sentence ever, that he, in this case appraiser, knows that the recipient intends to supply it. And the appraisal itself acknowledged that the bank may supply a copy of the appraisal to Mr. GELMAN. And in a refinance, unlike a purchase of a home where there's financing involved, there are only two persons or entities with an interest in the transaction, the lender and the borrower. Now, had the bank, or excuse me, had the appellee appraiser come back and come in too high with an appraisal, and Mr. GELMAN got his $10 million, he lost it all in the Gayfeather transaction because that was a bad business deal. Clearly, he could not come back and say, you were negligent in your appraisal and it caused me to lose money in a transaction you knew nothing about.
Would the bank, if the bank had accepted the two appraisals that your client brought them initially, that valued the property in the 30s, if they had said, okay, these look good to us and we're going to give you the money, and then it turned out that those were kind of fresh air and that the property was worth $5 or $6 million, would the bank then have a cause of action against those appraisers under your theory, even though at the time those appraisals were commissioned, the appraisers might not have known what it was going to be used for? Maybe your client just wanted to know what it was worth.
But that's, therein lies the problem, Judge. At the trial court, we never got past the pleading stage. It was a dismissal with prejudice at the pleading stage. We pled, the defendant made a statement thinking it was true, but it was false. That the defendant was negligent because they should have known the statement was false. That the defendant intended for, in this case, two parties to rely on it within the foreseeable zone of risk, and that in this case, the plaintiff, Mr. GELMAN, relied on, and the reliance has to be on a reasonable expectation of a non-negligent appraisal, because I agree, it would be disingenuous to suggest that the appraiser knew of the intended proceed of the funds. But every refinance, there is a commercially reasonable perception that the borrower is going to do something with that money. Money has value. put it in a passbook savings account, give it as gifts, use it for some commercial purpose.
So your argument is that the reliance is on an expectation rather than reliance on the appraisal itself, because I agree with you that the appraisal says that the borrower may rely on it. He had already entered into the contract to purchase the other piece of property months before the appraisal was done. So he didn't rely on the appraisal. You're saying that there's a reliance on the expectation of a reliable appraisal?
Yes, sir, because had we got past the pleading stage, I would have expected skilled counsel to raise as an argument, among other things, your gay feather transaction was pie in the sky.
But the appraisal doesn't say reliance on the expectation. The appraisal says you may rely on this appraisal. So, and I agree that that's what the appraisal says. So it seems as though by the clear terms of the appraisal itself that you're relying on, it's the appraisal rather than the expectation. Isn't that what the document says?
It is, Your Honor, but in my mind, and the panel may or not agree with my view, implicit in that has to be an expectation. The appraisal will be conducted within the USPAP or the professional.
Wouldn't you agree that if you read the terms and conditions of the appraisal, it says the borrower may rely on this appraisal?
Yes, sir.
Basically what they're meaning is the appraisal once it's done. You can take it and take the appraisal, and if you like it, you can use it and rely on it to do other things. But it didn't talk about expectation, it talked about the appraisal itself.
I agree, Judge. That's the facts of the case.
All right.
Counsel, let me just, I don't want to use up all your time, but let me ask you one question.
Sure.
We had an opinion that came out of our court not too long ago, and it was in the context of a legal malpractice claim, where folks who were third-party beneficiaries were trying to bring a breach of contract and or negligence claim against a lawyer. And what we said there was an attorney's liability for professional negligence is generally limited to clients with whom he shares privity of contract. If the parties are not in privity to bring a legal malpractice action, the plaintiff must be an intended third-party beneficiary of the lawyer's services. To assert a third-party beneficiary claim, the complaint must allege a contract, and I think this is the relevant part, an intent of the contract to primarily and directly benefit the third party, breach and damages. Is that an appropriate test in this instance? And if so, how was the contract between the bank and the appraisal to perform an appraisal for the bank intended to primarily and directly benefit the third party, which is your client?
Judge, that's an excellent question, because I think what your question establishes is the third-party beneficiary theory has been the law under appropriate facts, et cetera, the law in Florida for decades. When this court adopted 552 in the First State Bank versus Albright, there was, by necessity, some extension of law, because if I draft a will for my client and the beneficiaries of the will do not inherit because I made a big mistake in the preparation of the will, of course they're going to argue they're intended third-party beneficiaries, and they have the right to sue me. I think what 552 was trying to recognize in the restatement, and I think what this court recognized, is we have to, in a realistic commercial world, disregard some of these legal fictions that appraisers for years have insisted upon, which is the only party who can rely on this appraisal is the bank. That's not consistent with commercial reality.
Isn't that substantially different than the extension where the Supreme Court adopted 552 and Max Mitchell, where the accountant, Max Mitchell, gives apparently faulty financials to the bank, knowing specifically that the bank is going to rely on them? I mean, he knew that the bank was going to rely on them. a public accounting firm that audits, Exxon, knows that investors are going to rely on that. But, isn't that a significantly different fact than what we have here?
I think it's a different fact, but this court in Albright said, because in Albright, the real estate developers originally hired the appraisers. Clearly in Albright, the decision states that there was an update appraisal, and it was addressed directly to the president of the bank. And one could argue that that's a huge distinction, because nowhere here have we alleged that this appraisal was going to be given to the Gayfeather entity to justify some extraneous transaction between GELMAN and Gayfeather. The transaction was already apparently entered into under contract. So the question becomes, if Mr. GELMAN, as the borrower, had no right to assume a reasonable appraisal, then I think Judge Mihawk, I come back to where I started, maybe this panel will say, we recede from Albright to the extent that it appeared to expand the law. But I think respectfully, Judge Mihawk got it wrong when he said the appraiser could never owe a duty to a borrower when retained by the bank, because that's clearly not what 552 said, and it's clearly not what Albright recognized. And I think I've used up.
You've got just a little time left. I'll give you an extra minute and give
Thank you.
opposing counsel an extra minute. Okay.
He'll give you an extra minute. for
I'll give you
rebuttal.
an extra minute for rebuttal, so.
Thank you, Your
She'll have
Honor.
her turn, and then you can come back up, and I'll give you an extra minute. You've got maybe like 13 to 14
If
seconds.
she doesn't use all of her time, she can sell it to you.
May it please the court, my name is Jamie Bellotti Moses from Fisher Rushmore in Orlando. I represent the appellees Scott CAUFIELD and Southeast Appraisal Associates. My client, Mr. CAUFIELD, is here today with us. We are requesting that you affirm the decision of the trial court below. The trial court properly dismissed with prejudice Mr. GELMAN's complaint for the reasons articulated by this court in the questioning of the appellant. It has been acknowledged that there was no contractual privity between Mr. GELMAN and my client, and therefore the only basis.
There's language in the appraisal that says that the borrower may rely on the appraisal. And of course, counsel says that it's just not reliance on the appraisal, but reliance on the expectation that the appraisal will be done in a proper manner. Why isn't that an appropriate argument in this case? And one we should accept.
As a preliminary matter, I would just like to acknowledge, or to state that we don't agree that the appraisal was improperly performed by any arguments.
Assume that it was.
Okay. Because that is not, that, like you said earlier, the purpose of that is, let me back up, forgive me, Your Honor. There was a suggestion earlier that the only purpose of a refi is for a party to pull money out of their property. I think we all know that is not accurate. If there was a lower interest rate whereby they could borrow against the home, they would do so. But in that instance, that is when a borrower may rely upon appraisal. A borrower could also rely upon the appraisal if they got one done in January of a year and then 5 months later decided to sell the house and wanted to know the listing price whereby they would put it on the market. Well, we just had it appraised 6 months ago. The appraiser said it was worth $250,000. We're going to list it for $250,000. That is something that an appraiser takes into consideration when doing an appraisal. I have told you your property is worth, in this case, $13 million. I understand that someone might think that my opinion is it's worth $13 million. In this case, it's taken many steps further. There is a suggestion that my client knew that this appraisal had to come in at a certain amount. My client didn't even know about the Gayfeather deal, the oral promise to lend $10 million, the two prior appraisals for $24 and $26 million. My client knows nothing about this. My client is hired by Chase.
We don't know any of this stuff from, this is the pleading stage.
Correct, that's what's been alleged, that those were all done. They can't allege that my client had knowledge They haven't been able to allege that.
And I don't think, they haven't pled that. I think the question is, does 552 establish a duty upon which their client can justifiably rely?
No, sir. And 552 was adopted by this court in the Albright case. And that is the best example of what 552, why it extends liability beyond a contract. In that case, as counsel said, the developer hired the appraiser rendered an opinion as to the development, end of story. But it wasn't, because then the appraiser was asked to modify its appraisal and to direct it to the bank for purposes of the bank deciding whether to lend funds. And I believe in the Albright case, the appraiser went so far as to meet with the bank and discuss his appraisal. In that instance, that's where 552 is triggered. And to suggest that appraisers are hiding behind some sort of imaginary law out there and they're protecting themselves, in that instance, that appraiser went beyond his contractual relationship with the developer and started representing basically the developer in the negotiation to get the funding. At that point in time, the appraiser is putting himself on the line to the bank, saying, this is what I represent the property is worth, and this is why I think you should act accordingly. And that is subsection A of 552. In that instance, the appraiser intended for the bank to rely upon and act on his information that he was provided. That's also the Max case out of the Supreme Court. The accountants knew that their financial documents were going to be used by investors to make decisions. We have another case that I just can't remember the name right now, but it specifically said in a lease that an appraisal that was done at the end of the lease would be used by the parties to determine the purchase price of the property, and the parties would rely on that appraisal, and the appraiser was aware that the purchaser and the seller would rely upon that appraisal to reach a value for the sale, and they found that the appraiser would be liable. That's a reasonable interpretation of 552. In this case, we have, and again, the absence of allegations are telling. The absence of the allegations is the most telling point, because it's been alleged here the Gay Feather deal was entered into based on 2 prior appraisals not done by my client.
Excuse me, here's what the appraisal says. Paragraph 23, the borrower, any lender at the request of the borrower, the mortgagee or successors and assigns, so on and so forth, may rely on this appraisal report as part of any mortgage finance transaction that involves any one or more of these parties. So it says any mortgage finance transaction. Why wouldn't that create a duty on the part of the appraiser to prepare an accurate and reliable report?
Because we are not being sued on the mortgage transaction that never went through. We're not being sued on the $7.8 million transaction that would have gone through.
Well, his purchase of the other piece of property may have included a mortgage finance transaction. If it did, would that have made a difference? If he was trying to buy the other piece of property and obtain a mortgage to purchase the other piece of property and use part of this money as the part of the purchase price, would that have made a difference? Because it says any mortgage finance transaction that involves any one or more of these parties.
Well, okay. If that was to be read that way, that would mean that any transaction that Mr. GELMAN entered into with Chase, any mortgage transaction, whether my client was involved in it or not, because you're saying any mortgage transaction.
That's what it says. I'm reading the language of the appraisal report.
Right, and it says, you said paragraph 23, correct?
Paragraph 23, you can look at it, says the borrower or any other lender, and it may rely on this appraisal report as part of any mortgage finance transaction that involves any one or more of these parties.
And
This is a quote from the...
Yes, Your Honor, and I believe that is traditionally when a lender, for example, sells their mortgages. Subsequent purchasers of that mortgage can rely on this appraisal to determine whether it's appropriate to assume the liability under that mortgage. But it's important to note, in this case, we are talking about a deal that fell through, that was entered into before my client ever got involved. It was a $1.7 million deal that allegedly fell through because the bank wouldn't lend $10 million, it would only lend $7.8 million. How we can take the contractual terms of this appraisal, the Cooper holding and the Albright holding, to extend to a situation of that type is exactly what the Cooper court was saying we can't allow to happen. That is just too much. And I believe that's why paragraph 3 talks about the mortgagee or its successors and assigns. It's tying the reliance to this appraisal in this mortgage transaction, and it would have to be if others rely upon it in assuming the loan. Yes, sir. Again, Mr. Caulfield is not attempting to hide behind his appraisal and say only Chase is a party that can rely upon it. We acknowledge that Section 552 does expand potential liability if there is intentional conduct on behalf of the appraiser to induce others to rely upon his appraisal. It's been alleged that anything Mr. Gelman did in this case was based on 2 prior appraisals and Chase's oral commitment, and in fact, in the initial brief, it was specifically stated that basically my client's appraisal was so bad he didn't rely upon it and asked for another one. I do not believe, even with what Section 552 does to this area of the law, that it expands it to such an extent that my client could be liable to Mr. Gelman for a failed investment transaction that he never knew about. I mean, what if Mr. Gelman alleged that he was going to take the proceeds of the refinance and go bet on the horses, and somehow my client's appraisal didn't let him get the $10 million to bet on the horses, and now somehow my client is liable to him for that? That is clearly what the law is not anticipated to do, or to expand his potential exposure, or else an appraiser would never do an appraisal if that's what they could potentially be liable for. If there are no further questions from the court, I will rest on my brief.
Okay.
Thank you.
Thank you. I'll give you a minute and 8 seconds.
Thank you, Your Honor. The appraisal document is obviously a form document of some type used by the appraiser. And they can say in it who can rely upon it. And indeed,
Well, then it says in another part of the appraisal, the intended user of this appraisal report is the lender client. And then before that, the intended use of this appraisal report is for the lender client to evaluate the property that is the subject of the appraisal for a mortgage finance transaction. So, and then you've got in another part of the document that says that they can use it and rely on it for any mortgage finance transaction involving the party. So one part it seems to restrict it, and the other part it seems to open it up.
then I think to the extent there's an ambiguity created by that, it should be construed against the drafter, Your Honor.
All right.
Thank you.
All right, thank you. You both very
both.
much.